So guys, as you can see here, there are certain provisions which regulates the data set, that is which provides guidance on selection of the data set, right, particular comparable data. Now we'll go ahead with first rule 10b4, which provides for the data pertaining to the financial year which is to be used for comparability analysis. Now we'll just read that rule. Sub-rule 4 of rule 10b says that the data to be used in analyzing the comparability of an uncontrolled transaction with an international transaction shall be the data relating to the financial year hereinafter this rule and in rule 10c referred to as the current year. So data relating to the financial year, or if we are going ahead and reading rule 10c, then it would be a current year in which the international transaction has been entered into. So it says that for whatever year you are analyzing the data, so whatever financial year you are undertaking the transfer pricing analysis, for that particular data pertaining to that particular year needs to be considered for analyzing the comparability of the uncontrolled transaction with an international transaction. So this is what this rule entirely means. I am not going ahead with the provisions because the provisions are not applicable now after 2014. I hope that clarifies. Now I'll just move ahead to the next part. Now we just go to rule number 10b5, which says about data pertaining to the financial year to be used in case of RPM, CPM and TNMM. Alright. Now if I just go to sub rule 5, it says that in case where the most appropriate method for determination of arm's length price of an international transaction or SDT entered into on or after first day of April 2014 is the method specified in clause B, clause C or clause E. So clause B, of subsection 1 of section 92C. So if you recollect, section 92C subsection 1 provided for list of methods. So chronologically if you go, then clause B is resale price method, clause C is cost plus method and clause E is TNMM, transactional net margin method. So then notwithstanding anything contained in sub rule 4 which we read earlier, right, the data to be used for analyzing the comparability of an uncontrolled transaction with an international transaction or a SDT shall be. So now if you are dealing with RPM, CPM or TNMM, then you don't have to check the data of only current year, right? You can also go back. We'll just read that conditions. So the data to be used for analyzing the comparability of an uncontrolled transaction with an international transaction or a specified domestic transaction shall be the data relating to the current year, that is we read under that particular sub rule 4 as well, or so you can just emphasize on this particular part, it's or the data relating to the financial year immediately preceding the current year if the data relating to the current year is not available at the time of furnishing the return of income by the assessee for the assessment year relevant to the current year. So now when you are dealing with the methods which has been prescribed under clause B, clause C and clause A of section 92C1, then you can if the data for that particular year is not available, so for example for financial year 22-23 you are benchmarking a transaction, and for financial year 22-23 the same data of so the data pertaining to the comparable transactions is not available, then you have an option to go prior to 2 years before the current year. So that is financial year 21-22 and financial year 20-21. So you can use that 2 years data for undertaking your comparability analysis. That is what this particular provision says. Now it also has a proviso. We'll read that. So further the proviso says that provided that where the data relating to the current year is subsequently available, right? Now at the time of filing return it was not available, but then after once when you have filed return form 3CEB and you have taken the comparability analysis for that particular year, then after that where the data relating to the current year is subsequently made available at the time of determination of arm's length price of an international transaction or SDT during the course of any assessment proceeding for the assessment year relevant to the current year, then such data shall be used for such determination irrespective of the fact that the data was not available at the time of furnishing the return of income of the relevant assessment year. So there are two instances here. First is at the time when you prepare the TP report and at the time when you file form 3CEB. So probably the companies might not have uploaded their financial data on the MCA portal, right, with the company registrar. So at that point of time you might not have access to that data, right. But once when your assessment proceedings come, whenever the assessment proceeding come, you should always recheck the entire data of the financials which was not reported at the time of filing return of income in the TP report, right. So when you have filed return of income, you must have prepared that TP report, or you must have taken that analysis. Basis that you must have taken some position, right, under your return of income. So at that point of time, if data was not available, but after once when your assessment started before the transfer pricing officer, and at that point of time if you are required to submit the TP report, as a consultant you should also check that whether the missing data for that particular year and which is missing under the report is now available or not. If that is available, then that will be also considered when the transfer pricing officer will take comparability analysis. That is what this provision provides for. Now we move ahead to the next video.